Hello, everyone. My name is Maxim, and I'm a legal operations specialist here at Harley. And today we're going to discuss a really wide and informationally big topic that's called documenting relations in the United States employment practices. This topic is really wide, really huge. That's why it's divided into parts. And as you can see, this is the first part. Inside of this topic, we're going to discuss questions on documents that are used in the United States employment practices, questions on the basics of United States labor law, on its doctrines, and also on the ways and means of termination of such a relationships. So let's start. For the beginning, I think that it'll be logically to start with basics, and the basics are the basic doctrines in the United States labor law. As you can see, there are plenty of them. Still, I have to pinpoint that these doctrines exist throughout all the United States. They may vary in shape and contents, still, their essence is the same. These doctrines exist at the federal level, which is logically true, and in the state level legislation regulations. Uh, so let's start discussing them and briefly describing them. The first and the main is the at-will doctrine. This doctrine is really widespread throughout the United States, and basically it means that the employer may and employee may choose the time and reason for terminating labor relationships, where and for what reason they want. Still, this doctrine is limited by contractual provisions and provisions that arise from the legislation. For example, the employee cannot be terminated just because of the discrimination fact, or uh, if if termination from the reason that such an employee is being terminated is mentioned as forbidden in the contractual provisions. In such cases, at-will doctrine also does not work. The second is a right for collective bargaining and union rights. Basically, that's just a right that gives employees permission to unite into labor unions and by the means of labor unions withstand their labor rights. The third is the non-discrimination doctrine. I think that's pretty understandable. Or the only thing that's worth mentioning is that criteria for specific non-discrimination legislation is basically state-driven, not federal-driven. There exists federal legislation that's meant to protect people from discrimination on a federal level also. It's mostly obligatory for all the states. Still, the main criteria is mainly driven by the state legislation. The third is the Fair Labor Standards Doctrine. That's pursuant to Fair Labor Standards Act. This doctrine establishes the principles of minimum wages for overtime payments. It forbids exploitation and usage of child labor, and so on and so forth. The occupational or and safety doctrine that also is described in the OSHA Act is linked to bringing employees safe work conditions and for ensuring their right for acting if there are some kind of dangerous working conditions and working environment without the possibility of their termination from job. The next is employment contract and covenant of good faith. This is a pretty vivid but still important doctrine that establishes the right for the parties, for example, for the employer and the employee, to establish their legal relationships in the sphere of labor law, not by the at-will doctrine, but under written or oral contracts that cut off the at-will freedom of an employer. Regarding the good faith means that both parties are to strictly fulfill the contractual and oral provisions that they come onto while discussing the job, basic job conditions before hiring the person in the whole amount. The next is the right to privacy and employee monitoring doctrine. This doctrine exists for balancing the interstate interests of a state and basic interests of an individual and a person by protecting the essential and private information from being used under background checks and security checks in the process of entering a job. The last is the whistleblower protection doctrine. To be honest, the at-will doctrine, whistleblower protection doctrine, and fair labor standards doctrine are three that are, I'd rather say, basic doctrines that are basic for basics. The whistleblower protecting doctrine means that any employee cannot be terminated from his job because of telling the authorities or acting by the way that that helps to avoid unlawful behavior of an employee or of another employee or of an employer. So, like telling the police that your employer had done something that is illegal, may not lead to your termination under this doctrine. So in here on this slide, we can see the basic and most standard employment procedure in the US. It's pretty common to Ukrainian and pretty similar to Ukrainian and pretty similar to those in other countries. Still, it starts from a job application, then comes the recommendation letter, then comes the employment verification letter, and then the employment offer letter. That's pretty logically understandable, I guess. Still, as in here, you can see the main legal regulations that apply on every step of such an employment procedure. The first is the Title VII of the Civil Rights Act that gives the right for a job and for seeking job for the Americans as well as the Constitution. The second is the Americans with Disabilities Act, ADA. This is the act that is anti-discriminatory regarding people with disabilities and ensures the protection of their right for seeking and applying jobs regardless of their disabilities. The third is the Age Discrimination in Employment Act, which is pursued to halt any discrimination practices that are somehow connected to the age of an employee or the candidate for job offer. And the last is the Fair Credit Reporting Act, FCRA. This is the act that ensures that inside of a background check, credit history or other factors related to financial sustainability of a candidate or like future employee will not be the main reason for applying or not applying a job, except from the reasons and cases prescribed directly by law. These are most commonly connected to governmental jobs and civil service. So let's start like we've started, but let's start again by the employment procedure, and we are going into the job application form. As you understand, this document serves as the first introduction between the candidate and the employer, capturing personal details, education history, professional background, and specific skills. By signing it, the applicant affirms that the information is accurate, which transforms the form into a administrative requirement into a pretty legally relevant statement. The thing is that from that moment, when the candidate sends a future employer his application form with his personal details, becomes the employer becomes the one who's I'd rather say responsible for keeping such an information safe and for keeping such an application forms also safe to avoid a leakage of any personal data. What is to be included in such a form? A typical job application form in the United States is designed to collect standardized information, and therefore all the general information comes into like personal data, address, mobile phones, earned experience and previous jobs, work history, and so on and so forth. While not explicitly regulated, recommendation letters may be also subject to anti-discrimination laws under Title VII Civil Rights Act, which prohibits discriminatory practices in employment, and also to the section 1627.3 USC for the records to be kept by the employers, as that's the thing that I just described. The next comes the recommendation letter, which often comes after the application form. This document is not mandated by law generally, but carries persuasive weight in practice because it adds credibility to the candidate's qualification and gives a trusted third-party evaluation of their skills and character. Generally, that's a letter that says how the future employee is good in some kind of a sphere and like describes the experience of working together with other people from previous jobs or from the universities and so on and so forth. As I've told you, these documents aren't really legally regulated, still providing irrelevant, discriminatory, or just incorrect purposely incorrect information in such letters may lead to litigation. So one has to be really careful with them. Generally, what is to be included in such letters are is the information that you'd like to give about your colleague that's entering a new job, or that you'd like your previous colleagues or teachers or professors to give about you for the job you apply. I'll pinpoint it again. While not explicitly regulated, recommendation letters may be subject to anti-discrimination laws, which prohibits discriminatory practices in employment. That's important. The next comes employment verification letter. Sometimes employment verification letters are not legally regulated, but there are cases when they are not just legally regulated, but mandatory for entering any job. Employers often seek an employment verification letter after reviewing applications and recommendations. That's a common practice. This letter confirms factual details of candidates' prior work, including dates of employment, job title, and sometimes responsibilities on performance. In practice, many organizations issue only limited confirmation, such as name, role, and dates, to avoid liability unless the former employee consents to a more detailed disclosure. This process is regulated at the federal level, not the letter, but the process. By the Fair Credit Reporting Act, when third-party background checks uh, by the companies are involved, and by Equal Employment Opportunity Commission, um, by their guidances, requiring that verification practices not to be discriminatory. Uh, and also, here comes the sun. Here comes the legal provision which makes employment verification letters mandatory. That's the Section 8, USCS Article 1324A, that says that employees must verify employment authorization and identity using documents such as passports or social security cards uh, in the situation prescribed by law, and employers must attest to having examined these documents on Form I-9. These things that I've just told you about are mainly connected to the foreigners and to the specialists in specific spheres of labor relationships that have jobs and occupations which may be dangerous or require special knowledge and special obligations. For example, these can be employees inside of a sphere of a nuclear power energy, or foreigners that seek job permission inside of the United States. For for these people, they need to fill in the I-9 form, and for others, there are specific background checks and verifications regarding uh, regarding their professional skills and abilities, so they can occupy relevant job and positions that they are seeking for. Here you can see an example of the so-called I-9 form, Employment Eligibility Verification Department, from the Department of Homeland Security, that is used for foreigners that seek a right to work inside the United States. Yes, that's it. And after everything's done, almost everything is done. Since we may be lucky to get a employment offer letter or a job offer. Once preliminary checks are completed, the employer issues an employment offer letter. This document outlines the basic conditions of employment, such as job title, salary, benefits, start date, and sometimes contingencies like successful completion of a background check. Is it legally binding, or has it? Yeah, I'm sorry. It has legal force sometimes, and it's not wide, it's pretty limited. But in the United States law, the job offer or a job offer letter is considered as a part of the contract, since, as we've spoke before, under basic labor law doctrines, the contracts, including labor contracts, may exist in the written form, and even they can exist in the oral form. So basically, in most of the jurisdictions, it's not a binding document and does not create contractual obligations between the candidate and prospectively employer. Still, being under its legal nature a part of a contract, it may lead to litigation for example, defamation liability, negligent misinterpretation, or evidence in future disputes. For example, when a defamation comes into play, and there are some kind of defamative provisions in the job offer letter, this is the just cause for entering a legal proceeding and legal procedure for litigation um, uh, under the job offer letter, under defamation of it. The negligent misinterpretation inside a job offer letter is also the reason for litigation, as well as it may serve in evidence in dispute, since, as I've told you before, it may not be legally binding and has really limited legal force, but being a job offer, it is a contractual part of a relationship that exists between the employer and the employee, and therefore that's not the document that's worth lightweight attitude. The main regulations for job offer letters are the federal labor laws, of course. These are the Fair Labor Standards Act that we've discussed before, and the Family and Medical Leave Act. These indirectly shape the content of offer letters by ensuring that minimum wage, overtime rights, and leave entitlements are properly respected in such offers. States may also influence the format and wording, particularly where local wage and hour rules or background check restrictions apply. Offer letters may be subject to anti-discrimination laws under Title VII and the Age Discrimination in Employment Act also. And states, for example, like California, may require specific disclosures in offer letters, such as at-will employment clauses. Because in the state of California, at-will employment clauses are to be written inside the job offer letter and are to be discussed before entering a job position and starting and the start of conduction of labor role inside a job or a business. Generally, inside a job offer letter, that is not really legally binding or legally regulated, but as the mean of legal custom, inside of a offer letters, there are generally included the job titles, department names, reporting lines, start date, salaries or wages, at-will nature of employment or its absence, bonuses, stock options or commissions, if applicable, and so on and so forth. And in the situations prescribed by law that we've discussed before, the information about passing the background check on the I-9 form and other background checks. So generally, this is all for this lecture. Still, I need to mention that in the second part, we'll be discussing more interesting, as to me, more interesting topics as the non-disclosure agreements, labor contracts, non-compete provisions inside of such contracts, and non-compete contracts themselves, and so on and so forth. Still, thank you for your attention. Looking forward to hearing from you, and have a nice day, and wait for the part 2.